Let's rock. Okay, looks like we're ready to go. Now, let me close this. Okay. So good morning, everybody, or I guess it's technically good afternoon. This is the newest series in our workers' compensation lunchtime presentations, the infamous 1002 safe harbor process. As you will see on the chat, if you are Raina, you didn't miss anything. So if you look on the chat, which I guess maybe if you can't see it, there's the email address for seeking CE credit if you need it. So let's begin. So what is the safe harbor process? It goes by a couple of names: the safe harbor process, the 1002 process, the PD process, the preliminary determination process. It is essentially the same thing. But we're attorneys, so we have to seem clever, so we have to have multiple names for everything. But it's generally called the 1002 process or the 1002 safe harbor. But to understand the name, you kind of have to understand what a safe harbor is. It's a legal term that we use, a phrase, if you will, that may not be familiar to most people. It is a protection from an adverse action. So let's say you're a ship on the sea, you see a storm coming, you run into a safe harbor to protect yourself. Here, if you do everything correctly, you can potentially be protected from penalties and attorney's fees for certain actions. Now, the most important thing to understand, well, the second most important thing, I'll end this slide with the most important thing, is that everything you do in the 1002 process, you have to do precisely. The words that Mike will use in his presentation of how to do it, they are precisely utilized. So there is no ability for you to say, you know what, this would probably be easier. Certified mail, yeah, that's okay, but I think FedEx would be better. If they say certified mail, it is certified mail. If they say fax, it is fax. Nothing else will satisfy. If you try something you believe to be better, you have essentially waived your opportunity to enjoy the protections. Okay. Also, most important thing, and Mike and I probably get asked this at least once a month, the 1002 process is absolutely, positively not mandatory. If you or your company choose to ignore it, you are free to do so. There are no penalties associated with ignoring the process. You lose no benefits other than the safe harbor. You can still challenge accident, causation, course and scope, everything. You just, by not following the process or perhaps trying and failing, you simply lose the protections against penalties and attorney's fees that the safe harbor affords you. That's really it. So some people don't, if you can't do it, just don't beat yourself up.
Patrick, if I can, one of the things that a lot of adjusters misinterpret, and that is, oh, if I don't have safe harbor, and I'm talking about adjusters with 20 plus years experience. Oh, if I don't have safe harbor, then I owe penalties and attorney's fees. That is absolutely not right. You can go to trial and maybe the judge will award penalties and attorney's fees, but it is not mandatory if you don't follow the rules to get safe harbor. It just puts you back into a regular trial. So keep that in mind. It's not an automatic imposition if you don't do this.
Yeah, while the odds may not be in your favor, you never owe penalties and attorney's fees until the court tells you that you do. So how can you use it? It has a few issues outside that it was designed for, and a few issues that it was not designed for, but we've come up with a few that are chatty. So one, you can use it to initiate payment of benefits, and if done correctly, you can gain a safe harbor from any mistakes you make in either the calculation of the average weekly wage, the timing of the first payment, how you pay, all these little things that without the protections lead you into a potential penalty situation. by following the 1002 process, you can actually make a mistake and then have the ability to correct it. If you don't have the 1002 process, then if you make a mistake, you have to prove that you have to prove your actions were reasonable. And the courts, unfortunately, they don't accept your math as a reasonable mistake. So you gain the protections, you have a shield for any mistakes. If you don't have the protections, then you have a much, much, much harder road in front of you to not pay penalties and attorney's fees later. You can also modify, suspend, terminate, or controvert with the same protections. Because once you are in the 1002 process, then you can operate with those protections. You can go back and forth, okay, with utilizing the 1002 protections. You can modify, you can convert from TTD to SEBs. And if it's later proven, oh, he should have been getting TTD all along, then you can modify and you are okay. You can suspend benefits based upon certain actions. You can terminate benefits based upon certain actions. You can use it to provide a basis for full controversion. So not only does it act as a protection method, it also, and I don't think this was their plan, but it does work. It allows you to tell the claimant and the attorney what you are doing in a claim. It is essentially a notice mechanism. It broadcasts, here's what we are doing in advance of the change. Without the 1002, the claimant's attorney realizes, hey, I didn't get a check this week. He waits another week. I didn't get another check. Oh, well, they're late. Let me go pick up a penalty. I'm going to file a 1008. But with the 1002 process in play, even if you don't have the protections, it notifies them of what you are doing, and they become less inclined to jump the gun. You cannot use it to accept the claim as compensable. Now, that doesn't mean you don't try, but one of the things that most people forget about the 1002 process is you cannot use the protections if you have not initially accepted the claim as compensable. So let's talk about that. Unfortunately, Louisiana, despite having the 1002 process, which is hyper detailed, does not have a form where the adjuster has to accept or deny the claim. So it is a requirement that you initially accept the claim as compensable, but Louisiana doesn't have a form for you to initially accept the claim as compensable. Welcome to Louisiana, ladies and gentlemen. We have a full 70% of a normal functioning workers' compensation system. Now, what do? What we recommend is that in your claim notes, your adjuster's notes, your EDM notes, whatever you call them, if you get a claim and you are inclined to accept it with the employer's approval, of course, it's a witnessed accident, you're willing to give them the benefit of the doubt under the facts, then go into your claim notes and put, I am, and use this language. Initially, or the claim is initially accepted as compensable, subject to further investigation and subsequent controversy. Now, you can tweak that language a little bit, but you absolutely have to use initially accept as compensable. That's what the statute requires, so that's what you say. We put it in there that it is subject to further investigation and subsequent controversy, because in some states, as I understand it, you become locked into certain actions if you initially accept the claim as compensable. Not in Louisiana. You can initially accept the claim as compensable today and deny it tomorrow. But you have to initially accept. And again, it has to be in your notes. Otherwise, you will have to come to trial and hope that you can convince the court. Just put it in your notes. And look, if you're not sure, if you're still obtaining facts, you're still doing the investigation, the due diligence, just go ahead and put that language in. garner yourself the potential protections of the safe harbor. And if during your investigation you realize the accident didn't occur, then you simply controvert the claim. You lose nothing by initially accepting the claim as compensable. Now, of course, the employer may not be happy with that language, but you'll need to explain to them that it's a strategy decision. It's not a concession in favor of the employee. But again, there is no form for documenting the acceptance of a claim. I get that quite possibly weekly. Patrick, what form do we file to initially accept the claim? There is none. In the old days, it would be accepted that payment was enough. But then the courts found that they had a hard time awarding penalties and attorney's fees if they accepted mere payment as an initial acceptance. So then you started to see the requirement that there be something that can be pointed to, claim notes, a letter, what have you, that the claim is initially accepted as compensable for the 1002 process, the $750 limitation on unapproved medical expenses. So you have to document it in your claim notes. And I will tell you this, if you believe that you have done everything necessary for the 1002 protections, when you assign it to an attorney, please draw their attention to your claim note where you have initially accepted it as compensable. Because we will document on this date, the adjuster initially accepted the claim as compensable. So please make sure it's in your claim notes. Now, as to the third bullet point, again, going back to the old days, mere payment was not enough. Now, failure to pay is enough to be in a penalty situation. It's odd, of course, how that works out in Louisiana. But you always want to document in your notes that you have initially accepted these claims as compensable, barring some refusal to accept on your part or the insurance part. And that's universal to all claims. For those of you who work multiple jurisdictions, you understand in some states, you have to make that call early. You can do the same thing here in Louisiana, but you have to do it with your claim notes. Now, again, it does not lock you into anything by initially accepting the claim as compensable, but it is the price of admission for utilizing the 1002 process. And if you're familiar with it, the $750 limitation for non-approval of medical expenses. And before I hand this over to Mike, I just want to finish up by saying, look, the 1002 process is still alive. It is still functional, but a lot of this is dependent upon the adjuster. If it is not done correctly by you, there is nothing that we can do to fix it. So always keep that in mind. And look, if you have our workers' compensation training book, it walks you through the process. If you already have a copy of our quick reference guide, our quick reference guide walks you through the steps. If you don't have a copy, then please email us or contact one of us, Claire Oliver at parkerlandry.com. That's CLAIRELOLIVER at parkerlandry.com, and she can provide you this. And you just keep it handy. Okay, what's the first thing that I do? Because you never, ever, ever rely upon your memory when working a 1002 form. You always grab the quick reference and go, okay, I know I just did one yesterday, but let me double check for this one. Always follow the steps. You miss one mistake, as Mike will show you shortly, and you lose it. So always be precise. Now I'm going to pass this over to Mike. Mike is lucky enough that a lot of his clients are able to comply with it. Most of mine can't. So it's very rare that I have the opportunity to utilize the 1002 process. So Mike has much more experience in utilizing the process and having to convince the court that it was done correctly. So ladies and gentlemen, Michael Parker.
Thank you, Patrick. Sometimes it helps to understand how we got to this safe harbor process that we're talking about, because it didn't just materialize out of thin air. Before this process, there was a provision in the statute that allowed for the lawyers to get the average weekly wage issued before the court early on, and if you got it fixed, then you could avoid the penalties on attorney's fees. Some lawyers decided that they were going to take and try to expand this into this process that we have now. The problem is the plaintiff lawyers convinced the defense lawyers to make it so dang difficult that it is not impossible, but very, very, very difficult to comply with all of the rules. And so we don't see it used that much, but we do see it used. I was at a hearing about a month ago on one. But you know, these are the problems that you're going to face. And one of the problems when I say you're going to face is you as the adjuster probably can't control a lot of what needs to be done. So what you can control, I think, is this. There's a 1002 form. It's in the book, it's in our materials, it's on the website. You get the 1002 form and you fill it out. So you're going to mark off the initial payment. You're going to set out what the average weekly wage is. You're going to set out what the compensation rate is. You then take that form that is completed, it's compiled, and then what do you do with it? Well, you have to send it to the claimant. He's got an attorney, you have to send it to the attorney, and you have to send it to the workers' comp office. But you have to send it on the same day that the initial check was sent to him. So if you have a processing center in Portland, Oregon, that processes your checks, and you send out everything on July 31st, but the check doesn't get processed out of Portland until August 1st, then as Patrick has noted several times, you have not done everything flawless, and therefore you lose the safe harbor protection. So what do you do, or what do you tell your administrative staff to do when you have the 1002? So first thing you have to do is send it to the employee. Well.
Oh, and one thing before you were on that topic, if you're not familiar with that setup, again, like Mike said, the checks come out of a different part of the country, or if you're a new adjuster, at least one client we had understood that all checks would be cut on the same day requested, but only if the request was put in before noon.
Yeah.
So you need to find out from your I guess check cutting people, what's the latest that I can make a request to guarantee that it is cut on the same day. Then you give yourself an hour cushion. I mean, again, it's your headache. And if they say, oh, before noon, then you internally know that, okay, 11 o'clock, I've got to put all my requests in. The first thing I do in the morning is clear these 1002s. Again, this is one of those situations, ladies and gentlemen, that we have seen other adjusters mess up. So by attending these classes, you get to learn from the mistakes that someone else has already made rather than repeating them. But back to Mike.
So the statute begins by saying that you prepare the 1002, like we just talked about. And then it says that you send the notice of the initial payment to the claimant, and you send it to the workers' comp office within 10 days, along with the check being sent the same day that you send the notice to the claimant. Well, for years and years, we have taught this class that the statute does not require that you send the initial payment by certified mail. Later notices need to be sent by certified mail, but the first one did not. We always recommended that it was a good idea to send things by certified mail because then you have proof of it. So we have one about a month ago We have certificates of mailing of the 1002 to the claimant. We have certificates of mailing of the 1002 to the OWC. We have affidavits showing that the check was sent the same day. There's an objection to the request for a preliminary termination hearing that I made. We go and argue for about an hour and a half, and the judge in Lake Charles, in his infinite wisdom, said, no, you misread the statute all along. You have to send the initial payment notice by certified mail. Well, I've won preliminary termination hearings where we didn't do that. I've asked other lawyers that are long in tooth in this business, if you have to send the initial notice by certified mail, people on the plaintiff side, and the answer is, no, you don't have to send it by certified mail, except in Lake Charles you do. And so we're going to change what we tell people, and that is send everything that you have to send by certified mail. It's going to cost you a couple of extra bucks per claim, but don't run into the situation that I ran into where I thought it was frivolous that the attorney objected to our request, and then the judge agreed with it. And again, I argued till I was blue in the face with Judge Townsley, and he wasn't going to change his mind, and it wasn't worth taking it to the Court of Appeal. So 1002, to the claimant by certified mail on the same day that the check is sent to the claimant. You're going to need something from wherever your check dispersing arm of the company is to show that it was sent that day. Can it be by affidavit? Yes. Can it be by business record? Yes. Does the check itself have to be sent by certified mail? Right now, the answer is no. Would it be a good idea so that you can prove it later on? If you really, really, really want to get into the safe harbor, then maybe a good idea. I've talked to judges about this process, and I've actually had a judge tell me that, look, all I see it for now is a billing opportunity for the defense attorney. Said hardly anybody is winning on these things, and so not many people are doing them. But that doesn't mean that we don't want to try, because the protection that we get from the penalty and attorney fee issues, which we all know is the thing that we want to avoid. The last thing in the world you want to do is have to go and ask somebody for a $2,000 check for a penalty and a $2,000 check for an attorney fee because the average weekly wage wasn't done right, especially if we can fix it through the preliminary termination process. If the company is set up to be able to prove all of the things that you need to prove, then do it. Make sure that you get the information to your attorney when that happens. If you already know, and believe me, I've seen this happen where an attorney is the one who actually prepares the first report of injury, because the claimant doesn't say anything, disappears, then hires an attorney, and the attorney prepares the first report of injury saying, oh yeah, my lady got hurt 2 months ago. So you may have a situation where someone is represented when you have to make the initial payment. So if they are represented, understand that you have to fax the notice to the attorney. You don't have to send it to him by certified mail. You have to fax it to him. Now, why that makes a difference, why you have to do that, I can't explain the why. I can only tell you that that's the way that the statute is set up that you have to do.
That was the work of a particular plaintiff's attorney whose name I won't mention.
C. Ray Murray?
Yes.
I'll mention his name. Keep in mind that you also have to send This notice, the first notice, has to be sent within 10 days of the initial payment. Please don't wait and try to remember to do it 3 days later or 4 days later. Whenever you're sending out all of these notices, send them to everybody at the same time. Send the 1002, send to the claimant, send it to the workers' comp. If there's an attorney, send it that day. You want to make sure it's all being done the same. So that's the initial payment. So that's the first thing that you're going to do. And then, as Patrick has already mentioned, this form is used for lots of different things. Why there is one form that covers the entire spectrum of things that take place is another mystery. I've been told that they are working on changing the form so that you have an initial payment form, and then you have the modification form. The wheels of government turn slow, and nothing is going to happen this year because we've been through the legislative proceedings already. Didn't happen this year. Last year, you heard Patrick say that a claim is never accepted if you don't file a denial. There's actually some legislation out there where they were going to say that you didn't deny a claim within 15 days or 30 days, then it was deemed accepted, but none of that passed. So now you've been paying benefits. And let's say that you get some information from the employer that the average weekly wage that you thought was right is actually wrong. And so you need to modify what you're paying. And so let's say that you've been paying the maximum comp rate. One of the things that Patrick preaches, which is such good advice, is if you're not sure as to what the average weekly wage is from the employer, pay the maximum, because you're never committed to that for the entire claim. If you get the information later on that it's less than that, then we get to take a credit for overpayments. So let's say that you've been paying the maximum because you didn't have the information you needed to do an accurate AWW calculation. You then get the information and you say, well, I shouldn't be paying this guy $771 a week. I should be paying him $650 a week. So now what you're going to do is you're going to take the 1002 form, you're going to check off the box that says modification. You then take and say, okay, average weekly wage, it'll show you the boxes for AWW. Average weekly wage changes, your comp rate changes, and you can put for the explanation saying, got the correct information for the AWW. This is the one that we all thought before, but now everything should be done certified mail, is that you send this change, whatever the change is, the modification on SEB, the fact that you're suspending his benefits for not showing up for an SMO, the fact that you're terminating his benefits for fraudulent activity. We find out that the guy's been working, or that we're going to controvert a particular body part. They've been claiming the back all along. Now they want to claim a knee injury. And so you get a 1010 for that. So we're going to controvert all of that stuff. So like Patrick said, the purpose of all of this is notice. You're giving notice to the other side what's going on. So you send the 1002 by certified mail to the claimant. Where do you send it? You send it, you change that. You send it to the claimant.
Oh, yeah, it should have been changed there. I don't know why.
What you see here, there's just a little caveat with it under number one. You send it to the claimant at the place that he is receiving his benefits. So if you get a letter from an attorney saying, I want all the benefits to go through me, and the benefits go to the attorney's office, then that's where the certified letter to the claimant should go, notifying him of whatever change it is that you're going to make. Although you sent it to the claimant attorney by certified mail, because that's where the benefits are going, you still have to fax it to the attorney. So even though the attorney gets the certified letter, he has in his hands the 1002 notice of modification. You say, okay, I'm now entitled to safe harbor. And the attorney says, but yeah, where's the fax confirmation that you sent this to me by fax? And the judge throws you out of court on your request for a PD hearing because you didn't comply absolutely flawlessly with the rules. You also have to send, and this is different, you have to send notice of the modification on the same day to the Office of Workers' Comp. That's why we preach to everyone, anybody that will listen, we scream from the mountaintops, send everything on the same day every time. That way you're not having to try to remember what it is that you're doing. And so you've followed all of the steps. You've sent out the 1002 notice of modification that you're changing the benefits to SEBs, or you're reducing the benefits. Well, if you've ever looked at the last page of the 1002, there is a form that we never have to fill out, but it's called notice of disagreements. Well, that notice of disagreement is very important because if the attorney or the claimant, if he chooses not to be represented, wants to challenge what you've done. Let's say that you've reduced the average weekly wage from 1,000 to 700. And the claimant gets that and says, those people are crazy. And I've got proof that I was making $1,000 a week and they shouldn't be reducing my benefits. They have to file a notice of disagreement. So when they file that, if you don't fix what they claim you have done wrong, then they can file the 1008, the disputed claim for compensation. If they don't file the notice of disagreement, then they are unable to file a 1008. We file an exception of prematurity. And it's something that you really want to talk to your attorney about as to whether or not you're going to incur that cost. You're absolutely entitled to do so. But then what happens? You file the notice of the exception of prematurity. The attorney just runs out, signs the notice of disagreement, files the 1008. And so it really doesn't accomplish much, except it gives you some protection if they are going to file the 1008. So what happens now? So this is now at a stage where you're represented by an attorney. This is not something now that you are doing on your own. So there's a notice of disagreement. And the attorney says, here is proof that the average weekly wage, or the claimant says, here is proof that my average weekly wage is 1,000 instead of the 700 like you cut it down to. And you get that information and you look at it and you call the employee and the employer says, yeah, I mean, there was some stuff that we forgot to send you. And so it's like, okay, I need to fix now what I have mistakenly done. And so if you fix it after they send you what they believe the answer to be, you have 7 business days to fix the change. So if you change the average weekly wage to 700, you get information, it really is 1,000. You can then fix it, and guess what? You're protected from the penalties and attorney's fees for having done that. That's why this is so, the process is flawed, but if you can do it right, it's so important because these little nagging $2,000 penalties for the wrong average weekly wage that some attorneys go after on every case. They protect you from these little nagging things. You know, it's one thing to have an honest dispute as to whether or not somebody hurt their back when they sat down in a chair. Those are things that you need to fight and have a basis to do so. And if a judge disagrees, well, sometimes the judge disagrees and the judge is wrong. But these little nagging things that they get us for these penalties and attorney's fees are the ones that these protect. If the attorney, the claimant, sends you the information that he thinks is correct, and you talk to the employer, and the employer says, yeah, no, I don't know where he's got that from. That's not what we have paid him. And so you disagree with the notice of disagreement, the proverbial double negative. Then on the 8th day, because you have 7 days to fix it, on the 8th day, a 1008 disputed claim for compensation can be filed. So that's the claimant now filing a suit against you. So what do you do now? Well, it's now out of your hands, but you need to make sure that you understand the process so that you can make sure your attorney is doing the things that need to be done to protect you. So the attorney gets the 1008, the attorney prepares an answer. And the attorney doesn't see in your claim notes that you sent this out on the day that it was supposed to be sent out, that you sent it by certified mail, that you've got proof of this and proof of that, whatever. And he just files an answer. And then you get a copy of it and you call him on the phone and you say, or her on the phone and say, yeah, but what about the preliminary determination stuff that I heard them guys talk about the other day? And it's like, oh, guess what? It's too late. It's got to be done in the answer to ask for the preliminary determination. So they have now forfeited the right to do all of this stuff early on. What does that mean? Well, we go back to the beginning. It doesn't mean anything other than you don't get a preliminary determination chance to avoid the penalties and attorney's fees. It does not mean that you are liable for penalties and attorney's fees. Now it's just a question of, were you right when you disagreed with what they said was right? So, you know, the reason that you need to know this is so that you make sure that the lawyers that you are hiring are protecting your interests, especially on the penalty and attorney fee issue, as best as they can. Because there's no reason to pay a penalty if you don't have to. Again, it's something, you know, the tip there. You know, it's something that when you make an assignment to whoever it is that you're going to assign the case to, not just say, oh, here's a 1008 I received and then got 15 other things that are due in the next 10 minutes and don't say anything. I mean, make sure that the attorney that you're sending this to understands what you've done so that they can protect you the best. Yeah, you look like you wanted to say something, Patrick.
No, I'm just trying to stay away.
Okay, yeah, I don't know. It's all boring. Sorry about that.
Especially considering how often I actually get to use the 1002 process.
And so what happens? So your attorney then has kindly requested a preliminary determination. The first thing that happens that's not on here is that the plaintiff attorney is likely going to file a motion to strike the request for a preliminary determination hearing, because that's what happened to me in the case I had about a month or so ago. That is then set for hearing. And you have to do sort of a preliminary proof that you've done everything correctly. And while I thought 100% we had done everything correctly, the judge decided that you needed to send an initial notice of payment, certified mail. And so we didn't go through the next steps that are here. So after that, the next step, and they don't have to do it, the plaintiff attorneys don't have to do it, They usually do just to test the waters to see. They don't have to, but they usually do. And so then what happens? Then there's a phone conference. And so again, you need to kind of be watching what the reports are coming into you from your counsel as to what's going on. So there's going to be a phone conference set by the court. There's then going to be deadlines that are set for discovery, for depositions, for things that need to be done that are going to be limited to the issue in whatever you've done. The modification is, so if it's just on the average weekly wage, then the only thing that ought to come into evidence, the only thing that ought to be discoverable is the information about the average weekly wage. If it's fraud, it ought to be just the stuff on the fraud. So there shouldn't be this grand blown up discovery process that goes through everything in the world for this preliminary. That's why it's called preliminary determination process. So once you get after the conference, they'll then set a hearing where you have the information that's presented by both sides. It can be by records, it can be by deposition, it can be by stipulation, whatever it is that you've got that the attorneys can agree upon to give to the judge, then the judge has the evidentiary hearing. The judges are required by statute to issue a ruling within 30 days. The problem is if the judge doesn't issue a ruling in 30 days, who's going to be stupid enough to call the judge on the phone and say, Judge, would really like a ruling on that case we tried in front of you 45 days ago. And the judge says, oh yeah, I remember now. That's the one I'm going to rule against you. So we never recommend challenging the judge on the 30-day rule. You just, every now and then, maybe if it gets to be 60, maybe you send a joint letter from the attorneys. Judge, is there any more information you need or from us to help you decide? So.
One more slide.
Oh, one more slide. All right. So this is the last of you getting to hear me yak about this stuff. So the judge rules. And so what do you do? So if he rules against you, then you can say, okay, I'm protected from penalties and attorney's fees, and I'm going to fix whatever it is that the judge says I did wrong, as long as you do it within 10 days. So if you fix it within those 10 days, then you are protected once again from penalties and attorney's fees. Again, why it's important if you can do this to do so. What if you say, Judge, you're an idiot? You can't say that out loud or put it in your notes, but you can think it. Judge, you're an idiot, you're wrong, we're not going to do that. Then the case just proceeds through the normal process. But again, what you need to be looking for from your attorneys is, when did the judge rule? I mean, did you wait 7 days to send me this? Bless you. Did you wait 7 days? Because if the attorney says, oh, look, here's the ruling, but you may only have 3 days in order to get everything correctly done if you need it to be done that way. So make sure that you're staying on top of when that ruling is going to come in. You know, maybe have a diary after 30 days or maybe after 15 days to say, hey, do we have something? Hey, do we have a ruling? Do we have a ruling? But if you decide not to accept, you say, no, we think the judge is wrong, you come to that conclusion, then now you just go to trial. You know, the judge says, yeah, you are liable for penalties and attorney's fees, then you're liable for penalties and attorney's fees. So that's pretty much gets you to the end of the process. So initial notice, send it out same day, certified mail, send it to OWC the same day. If there's an attorney, fax it to the attorney. You do something to modify, send it certified to where the claimant is getting his benefits, fax it to the attorney, same day to OWC. From there, the process kind of gets out of your hand because there's the notice of disagreement, or at least after this part. The notice of disagreement comes in, you say, okay, you're right. We're going to fix it. You're protected. After that, if you say, no, you're wrong, then it gets into the 1008 process. The attorneys get involved. You just need to make sure that your attorneys are asking for the things they need to ask for at the right time, and that they're sending you the information at the right time for you to be able to comply with whatever needs to be complied with. And back to Patrick.
Okay. And for those of you who are sitting around going, well, this process is absolutely absurd. Yes,
Yeah.
yes, it is. Okay.
It's hard to argue with that.
It is almost non-functional. I know the attorney who had his hand in it, and when we first presented this at a seminar, myself and Judge Lanier, he was like, yep, that was me. Yep, that was me. So it was a bone thrown to the defense bar. Look, this is these are some protections that will let you have for penalties and attorney's fees, but will make it almost impossible for you to comply with. And to be honest, very few out-of-state carriers or TPAs can comply because of the check issuance issues. If you are a Louisiana-based TPA or carrier and you are able to issue checks from your own office, then this is something you should be doing routinely. This should be drilled into your adjuster's hands as to how they do things every single time. But if you read that entire statute related to the 1002 process, we were able to sneak in a few things that really do help us. And in many ways, we use these more often than the 1002 protections for those of us who don't get the opportunity to enjoy it that much. And it's the expedited hearing. Now, if you take the time to review the entirety of the Workers' Compensation Act, it says that you can do certain things. But the courts over the years have said, no, you can't. So, for example, it used to be a situation that if the claimant did not attend a second medical opinion, you could terminate benefits as a punishment for them not attending. But some attorneys on the other side would argue that, no, you need court approval to do this. And it became a constant battle. Did you need to go get court approval? Well, wait a minute. How do I get court approval if the matter's not litigated? How do I get this before the judge? This was somewhat answered within the statute that gave rise to the 1002 process. And it allowed us expedited summary proceedings. We can now put certain issues before the court. Now be advised, so can the attorney. The other attorney can also put matters before the court, almost outside of the formal litigation process. So, the normal 1008, we're fighting, we're not agreeing, we're challenging this, that, or the other. That's the normal process. And for years, we could only raise these issues if we had a 1008 in which to argue. The expedited summary proceedings are a way to put the matter before the court without a formal 1008, but here's where things get confusing. You still have to file a 1008 because you need a docket number. It's Louisiana, ladies and gentlemen. It doesn't have to make sense. It simply is what it is. So you are filing a 1008, a disputed claim for compensation, while telling the judge you are not disputing anything. You actually have to put it in the cover letter and in the 1008. We are not disputing anything. We just need a docket number to do one of these following actions. The employee's choice of physician dispute. Employee wants to go see a choice of physician, or initial choice of physician, and we disagree. We're not accepting anything. The attorney can file a summary proceeding to compel you to be granted the one-time initial choice of physician evaluation. We all know this. You get the letter of representation. My client wants to see Dr. X. We hereby request the initial evaluation with that doctor. If you don't provide it to us, penalties and attorney's fees. Because some courts will grant that in anticipation of trial, okay, whereas for years we would say, oh, that's a trial issue. Some courts will now actually award penalties and attorney's fees at this actual hearing. So it allows the attorneys to formally bring this matter to the court early on and say they're denying me my choice of physician, which unfortunately the judges will almost always grant unless you have a solid defense to accident, course, and scope, what have you. The employee disputes over vocational rehabilitation. The attorneys plaintiff's attorneys don't really use this one that much because they don't want vocational rehabilitation. They like their client not having a wage earning capacity. So an attorney or the claimant can actually file an expedited hearing to be granted vocational rehabilitation efforts to be able to return them back to the workforce. Frankly, I've never seen this. The employer seeks to have the employee execute an 1121 choice of physician. This is magical. Ladies and gentlemen, this is huge. The employer, Louisiana does not have de facto choice of physician. A claimant can treat 10 years with a doctor, can undergo 3 surgeries, and the doctor goes, okay, you can go back to work. And the attorney, their new attorney, because they didn't have an attorney before, this new attorney pops up and goes, wait a minute, did you ever sign a choice of physician form? No. That claimant can, and I am not kidding, can put a new doctor's name on an 1121 form, and they now get a new doctor. So why is this useful? You can force them to sign the 1121 if they refuse, and you can prevent them from doctor shopping. Whereas in the past, we could ask, and we could ask nicely again. Now, if they refuse, then you can force them to commit to a doctor using an 1121. Ladies and gentlemen, in every single one of your files, if a claimant is treating with a doctor for which you do not have an 1121, you go get an 1121 right now. Because Louisiana, it is very easy for the other side to doctor shop, go get a new doctor, until that name appears on that form. They can change, but it's an uphill battle. Every single doctor who is treating your claimant should have an 1121 in the file. The employer seeks to compel employee to attend an SMO or IME. In the past, we can just cut them off, which then forces the matter into litigation. So what you can now do, if you don't want to run the risk of a penalty and attorney's fee for suspending benefits for failure to attend, you can file for an expedited hearing to compel them to attend. Some adjusters, TPAs, carriers are more penalty and risk averse. If the claimant doesn't go to an SMO, they may not want to risk a penalty to cut the employee off to force them to go. They may make me file a motion to compel attendance. The court will make them go, but you haven't risked a penalty by cutting them off. Some clients, on the other hand, are just, well, I'm going to cut him off. I'm going to make him go. Okay, that's an option. Everybody's different. This is a way to get them to go to the SMO or IME if you are more risk averse. Employer seeks to compel employee to complete a 1025 EE or 1020 forms. This is another one of those must-haves. And I mean every, and I literally mean every single file you have in Louisiana, you must have the claimant execute a 1025 EE form. It's available from the Office of Workers' Comp. It's available on our website. This form says you cannot collect indemnity benefits for being unable to work while you are earning wages. And it says quite clearly that it is fraud to do so. So let's get quick example. Patrick, I have video of the claimant now working somewhere else and I'm paying TTD. Okay, do you have a 1025 EE? What's that? Okay, well, what that means is the claimant is likely going to tell the judge later, I didn't know I couldn't work on the side. And the courts tend to give them a one-time bite at the apple. It'll tell them, don't do that, or you're now an SEB candidate. You can work, but you just may not be working as much for. But if you have that signed 1025 EE and you're paying TTD and you find video of them working on the side earning a wage, you have a very strong case of fraud. You only get that strong case of fraud if they are seen earning wages after the 1025 EE form is signed. That should be in every single one of your files. It will gut you, and you are going to have a very uncomfortable conversation with your customer if you have to explain to them, hey, yeah, we got video of them working while we're paying them benefits for being unable to work, but the odds are the court's not going to treat it as fraud because I don't have a signed copy of this form. Not a comfortable conversation with the customer. Now, if they don't provide it, you can ask the court to make a 1020 form. That's the form they supply you monthly for SEB calculation, loss of earning capacity calculations. I was making this much before, I'm only making this much now. As soon as an employee has an ability to work, sedentary, light, what have you, it doesn't matter if the employee has a job to go back to. It doesn't matter. If the doctor says, the treating doctor says he can work at super duper extra sedentary duty, you immediately convert them to SEBs on the 1002 form and you demand 1020s. Because the 1020s require that they truthfully disclose their earnings over the previous month. The fraud language is in there. If the employee is working, but they're not fully disclosing their earnings history to maximize their recovery, that can give you fraud. Again, same situation as with a 1025 EE. Patrick, the claimant has an ability to work light duty, and he's sending me 1020 saying he's not working, but I have video of him working now. Wait, you have a signed 1020? Great, you may have fraud. If you don't have the 1020, then the court may grant them an out, but they're a little bit less inclined for a can work. They want a much stronger version of fraud because the guy is actually working. You have that form signed, it's very strong fraud. The moment, and I know, look, if the claimant doesn't have a job and a wage earning capacity established, it may be just easier to keep him at TTD. Absolutely not. You never do that. As soon as they can work, you convert them to SEBs because that 1002 saying my guy, your guy is now getting paid SEBs to a plaintiff's attorney who knows there is a maximum payout for SEBs. That attorney is now going to go, uh-oh, the clock is ticking, I've got to settle. If you don't tell them they are getting paid SEBs and you continue to pay TTD because you don't have a wage earning capacity offset, the plaintiff's attorney is going to think to themselves, well, I don't have to look at that file. He's going to get a check next week. He's still getting TTD. So you can use that. I know. You can use that check, that 1002 form to tell them, hey, it's SEBs, go look at your calendar and get me a settlement demand. Finally, if you have a suspension in place for failure to go to an SMO, failure to go to an IME, attend voc rehab, what have you, the plaintiff's attorney can now file a motion with the court for you to go ahead and restart payment of those benefits because he did go to the SMO. It's essentially pointless. I don't pick this fight. If he goes to an SMO, I just go ahead and restart benefits. But it's the opportunity if you want to pick a fight. Yeah, sure, your guy went to the SMO, but he didn't say anything. So you leave that penalty in place. But normally if they go, they're going to play by the rules. And you just go ahead and pay. But that option is there. So in conclusion, look at our training book, look at our quick reference guide, or look, if you want to use someone else, I'm sure they have one, then use that. Because it is very, very, very precise. It is very, very particular. But if you do not have the ability to comply, your company simply cannot do it. The 1002 does have uses. It does warn them your guy is now an SEB candidate. You need to look at settlement. The clock is ticking. It does keep a plaintiff aware of what is going on in his suit. Just because you can take an action doesn't necessarily mean an unrepresented claimant fully understands. This is how you let them know. So there are a variety of uses for the 1002 process. But again, precision is the watchword. Absolute flawless precision is the watchword for the 1002 process.
I think we need to give some like words so that you can get your hour if you're looking for it.
Yes, and
So
let's
preliminary.
let's go to this. Flawlessly, all must. And there should be more, but it's one of these things that I'm trying to impart information, not necessarily make sure that you flawlessly attended each word. I mean, for one of you who's attending, I can actually see you paying attention. So I will be able to, if I need to, right now.
She's working a crossword.
But again, ladies and gentlemen, we're always here. Reach out to us if you have questions and supply us your information. If you go look at chat right now, here's where you send us the information. And thank you for giving us this opportunity to waste your lunch by making you smarter in Louisiana workers' comp.
Thanks, everybody. Appreciate it.
Thanks, everybody.